Okay, so we're here to talk about this afternoon the Redeem Act. Thank you everyone for joining. There will be an opportunity to put questions into either the chat or Q&A box. Feel free to use that feature at any time during the presentation to ask questions. And we'll go ahead and jump in. So here's a quick kind of table of contents for the presentation today. I'm going to go over expungement of convictions in general and the basic procedure for how that works. And really, once you have that foundation, or even that just quick refresher, if you're familiar with expungements already, you'll be able to pretty easily understand the Redeem Act. The Redeem Act actually deals only with the expungement of convictions. So we're not going to be talking generally about expungement overall today and how it works in Maryland, but just focusing on the expungement of convictions and the way that the Redeem Act changes them. And then we're going to go into sort of just the broader implications of what we think the expungement landscape is going to look like in Maryland, really just focusing on kind of how this is going to affect people seeking expungement, and then give a little bit of information about some of the changes to the expungement forms and how you can go about assisting clients with the expungement procedure. So as a quick refresher on the expungement of convictions, the Redeem Act was an amendment to Criminal Procedure Section 10-110. This is the enumerated list of the types of charges that are potentially eligible for expungement if a person has been convicted. So 10-110 is really just a long list of specific crimes that have been singled out as being potentially eligible for expungement if a person is found guilty. And I say potentially because there are certain requirements that a person has to meet. In 10-110, there are two main prerequisites required for eligibility. Those are the waiting periods and the subsequent conviction rule. The waiting periods are really what the Redeem Act deals with primarily, and the basic way that they get calculated remains unchanged in the sense that the waiting period begins when the defendant has satisfactorily completed all portions of their sentence. That accounts for periods of incarceration, parole, probation, any sort of mandatory supervision or anything like that. All of that must be completed before the waiting period actually begins counting down. There was recent case law that basically interpreted this satisfactory completion provision to mean that if someone has a violation of probation and the court closes the probation period unsatisfactorily, this actually will not count as satisfactory completion of a sentence, and therefore the waiting period actually can never begin counting down, meaning expungement is not possible. That is sort of its own can of worms that could be discussed in a separate presentation. I won't have time to go into details of that decision. It is actually most likely going to be getting looked at in the upcoming legislative session and potentially be fixed statutorily, but that's something to keep an eye on. And then the subsequent conviction rule. In other words, no ineligible convictions can occur during the waiting period. That would block expungement. So if you have a new conviction that occurs within the waiting period, and that new conviction is ineligible, meaning it's not on that enumerated list in 10-110, it permanently blocks expungement of the previous case. If the subsequent conviction is itself eligible, you essentially just go into a situation where you're waiting for the waiting period of the more recent case to come up, And when that waiting period ends, any eligible cases that happened beforehand become eligible. And the statute does say becomes eligible. In other words, you need not expunge the subsequent conviction before the older ones become eligible. You can file all petitions simultaneously for cases that are eligible. And a couple more quick notes on the expungement of convictions. These are rules that actually apply to all expungements, but it's important to remember the pending case rule still applies in the world of the Redeem Act, meaning the petitioner cannot be a defendant in a pending criminal proceeding. And I like to caution people that this is often called an active case rule, but I think that that's a misnomer. An active case is really something that could mean a number of things. It's often just sort of a clerical designation, maybe if the person has outstanding court costs owed. Someone could be on probation, and sometimes certain courts or certain clerks might mark the case as active in case search. However, the statute says pending criminal proceeding, a defendant in a pending criminal proceeding. And there actually is case law that defines that language as a criminal prosecution that has not yet been adjudicated. So if someone were incarcerated after a conviction, it's no longer pending. There's been a judicial determination of guilt. The prosecution has ended. So if someone is currently serving their sentence, they no longer are a defendant in a pending criminal proceeding. Someone incarcerated or on probation, parole can apply for expungement of other cases if those cases are, of course, eligible. But it's important to note simply because the word active pops up a lot. You see it on case search. It is a red flag. You want to look in and make sure that it's not pending, but the word active on its own is not an automatic bar to expungement. And then, of course, the unit rule is still going to apply when we're looking at convictions in the world of the Redeem Act. So the unit rule states all charges within a case must be eligible for expungement in order to expunge that case. Stated another way, you cannot expunge individual charges out of a case. You can only expunge a case. So if you had 3 convictions in a case and 2 of them were on that list in 10.110, say they were misdemeanor theft, but one of them was armed robbery or something that is not eligible, the entire case becomes eligible. And a unit is essentially defined as charges that arose from the same incident. So it's usually going to be one arrest for one, particular event. And if there were multiple crimes committed, they become a unit for the purposes of expungement. So that's just a basic overview of the way expungement of convictions works in 10.110. Again, as a reminder, this presentation is really going over the Redeem Act changes, not it's not really an expungement 101 training, which we do have on our website for anyone interested. So getting into the Redeem Act and specifically what it does. Once you have sort of that foundation of how expunging convictions works, it's actually very simple. And if you are familiar already with expungement, it's really just learning the new waiting periods that apply. And if you are new to expungement, you're really just going to be learning the current waiting periods. The Redeem Act went into effect October 1st, so just a few weeks ago, as we hold this presentation in mid-October 2023. And these are the new waiting periods that apply. Really, the Act created 3 categories for eligible convictions: 5 years, 7 years, and 10 years. Previously, we more or less had a 10-year and 15-year categories only. So we're looking at 5-year waiting periods for all eligible misdemeanors enumerated in that statute, unless otherwise accepted. And then really the only exception that there is second-degree assault, perhaps common law battery as well. Those are 7-year. So really all misdemeanors used to be 10 years or 15 years if accepted, and they're now going down to 5. And the 15-year misdemeanor exceptions are going down to 7 years. Also housed in that 7-year category is basically all eligible felonies unless otherwise noted. But the way that that breaks down is there really are just 2 felonies that fall into that category as the statute currently stands. That is CDS, possession with intent to distribute, and 3rd-degree burglary. Maryland also has a 4th-degree burglary, which falls into the misdemeanor category. And as a side note, I will mention that CDS, possession with intent to distribute, the law is actually affected by the cannabis legalization that went into effect in July. So that conviction is going from 15 years down to 7 years, unless the substance was solely cannabis. Then it actually has gone all the way down to 3 years. Although that is really just an aside because that's not part of the Redeem Act. That's part of the cannabis legalization. But important to note, because you do have to take into account what the substance was when analyzing CDS, possession with intent to distribute. I'll also note that CDS distribution and manufacturing is a separate crime from possession with intent, and it is actually not eligible at all under the current statute. And then in the 10-year category, you have the felonies that are specifically accepted from the 7-year rule. Those are felony theft, 1st-degree burglary, and 2nd-degree burglary. Felony theft is defined in the criminal law code based on a threshold of the dollar amount that is alleged to have been stolen. So under it is misdemeanor, over the threshold is felony. That dollar amount has been raised over the years, and there isn't actually a lot of guidance in the statute, if any, in terms of, do you apply the threshold that existed at the time of the arrest or not? Generally, it seems like courts are applying it that way. So if someone was convicted of theft in the 90s and they had stolen an amount that would now be a misdemeanor, it does seem that courts generally still treat it like a felony because it was a felony at the time. But there's certainly room for argument and presenting a case before the court if for some reason the calculation worked out that you wanted the court to consider it to be a misdemeanor under the current law. And I did say that there were 3 categories that are created by the Redeem Act, 5, 7, and 10 years. And I did mean to say 3 categories, but I have this 15-year category still on here because it's really just an outlier. This is something that remains untouched by the Redeem Act. There is this exception in 10.110 that says any offense classified as domestically related that would otherwise be eligible is at a 15-year waiting period, and that is not changed. That is something that is at the discretion of the state's attorney to basically just categorize the offense that they are bringing against the person as domestically related. So commonly you might see that in like 2nd-degree assault, malicious destruction of property, maybe even unwanted telephone harassment, things like that. And this is just at the discretion of the prosecutor. It should be on case search if you're viewing an offense. Um, it's actually something I've never seen. I've never come across this domestically related offense categorization in all the expungements I've done, but it is in the statute. It is important to note that it would be a 15-year. If, for example, if you want to double check when you're looking at something like second-degree assault, where that might commonly be charged after a domestic dispute, that's something you can keep an eye out for. So that's the changes to the waiting periods that are enacted as of now while we're speaking under the Redeem Act. But there's one more little thing that the Redeem Act did besides change the waiting period. It actually added a new conviction to the eligible types of charges in 10110. That is malicious destruction of property. And that's going to go into the 5-year misdemeanor category. This is something that a lot of advocates were really excited about. It was actually something that was sort of added into the bill at the last minute, and it went through. And it's exciting because this is a conviction that we see a lot at MVLS, and it has held up tons and tons of people from getting cases expunged that might otherwise be eligible. And the phrase malicious destruction of property certainly doesn't sound nice, and it certainly doesn't look good to an employer or a potential landlord or anything like that. But the reality is, from what we've seen, what we've observed in processing lots of expungement cases, is this is more or less treated like a pretty minor offense in the court system in many cases. It's often charged after a domestic dispute or some sort of kind of minor altercation or argument where the police are called. And because of the fact that it seems to be relatively a minor offense, it's sounding like a lot of people end up taking a plea deal and plead guilty to this offense and usually avoid really any major punishment of any kind, but accept the plea deal rather than going through the whole drawn out criminal trial process. So then a lot of people end up with this on their record, and it was not eligible for expungement for many years until now. So this will probably open up a lot of cases to be expunged. And that's what I'm going to discuss on the next couple of slides, the implications. So what are the implications of the new waiting periods on the Redeem Act? Well, the obvious thing is lower waiting periods means more people eligible for expungement sooner. That is pretty obvious and seemingly the main goal of the statute. However, I think interestingly enough, maybe slightly less obvious will be how many cases get opened up due to fewer subsequent conviction rule violations. If you've done expungement recently with the Justice Reinvestment Act and the opportunity to expunge certain convictions, then you'd be well aware of the way that these long waiting periods have created so many opportunities to violate the subsequent conviction rule. And it sort of creates this tapestry where these 10, 15-year waiting periods are getting dragged out into 20, 30, 45 years with just a handful of convictions. And that is going to be a lot less of a dense minefield with the Redeem Act in effect. And I think that is really going to be the ultimate power of the Redeem Act, even more so than just the lower waiting periods on their own. And what do I mean specifically? This is an example, just a fictional client case, a record that you might see when consulting a client. So on the left, what the law used to be before Redeem, on the right, what it is now as of October 2023. So imagine this is a client, just one client you're consulting with, and these are the only 3 cases on their record. The year 2000, they had a conviction, and imagine they're all convictions. Conviction for second-degree assault. Even for simplicity's sake, assuming that there's no incarceration or anything, maybe they just imagine they got time served, they'd be waiting till 2015 to be able to expunge that case. In 2010, if they get a misdemeanor theft conviction, their waiting period for both is now bumped up to 2020 on a 10-year wait for that misdemeanor. And then if a conviction in 2018 happened for trespassing, that was 10 years. So they'd be waiting until 2028 at the absolute earliest to expunge. So looking back to 2000, someone waiting almost 30 years to expunge that second-degree assault. And again, this is the simplest possible scenario where we're assuming sort of a fantasy situation where there was no incarceration, probation, etc., for any of this. If there was, the waiting periods could be even longer. But now with the Redeem Act, the same exact charges, the same exact convictions on a person's record would all be eligible probably right now. So in 2000, you'd actually be looking at 7 years from that case. There wouldn't even be a subsequent conviction rule violation for the misdemeanor theft, nor would there be a subsequent conviction rule violation in 2018 because the misdemeanor theft is down to 5 years. So trespassing, also 5-year misdemeanor. We're looking at 5 years from that. It's 2023. If this was a client who you were consulting with, you would probably be able to tell them that their entire record is eligible for expungement. So we're looking to probably see a lot more of this. It's really an exciting time for expungement. If you've done this work before, you probably are familiar with the feeling of having to give people bad news if they have convictions on their record. We're hoping that we're probably going to be able to give people more good news than we're used to giving them, that more cases are eligible for expungement. There's also a new court form, getting into a little bit of the procedure, which really remains unchanged. But the court form is also an interesting opportunity to talk about the specifics of the law as well. The form is pretty much the same. It just adds those 3 categories that now exist as opposed to the 10 and 15-year reasons for eligibility. It adds those check boxes for 5, 7, and 10-year eligibility. But I really like to note that the court form language is very misleading and, in fact, incorrect. It's really interesting to note this highlighted section, which, if you'll see, the 3 check boxes are really just a long-winded way of saying the 5-year, 7-year, and 10-year waiting periods have passed for the applicable offenses. Each one contains this language that's highlighted saying, since the date of conviction, I have not been convicted of a crime not now eligible for expungement. That is actually an incorrect phrasing of the statute. If we look at the subsequent conviction rule itself as stated in Maryland Criminal Procedure 10-110, the law itself, it says, if the person is convicted of a new crime during the applicable time period, then there is a subsequent conviction violation, and you have to wait until the new conviction becomes eligible for expungement. So that clearly states that the subsequent conviction only counts against the petitioner if it occurred during the waiting period for the original case that they seek to expunge. Meaning, according to the language of this form, if someone had a conviction in maybe 1980, and then they had another conviction in 2020, that form would call that a subsequent conviction, even though they were 40 years apart. And that's incorrect. So you can't base your interpretation when you're filling out the form. It only seems natural to say, okay, I'm double checking the form. My client has this misdemeanor that is specified in the article. It has been 5 years, etc. Certainly any lawyer would think it was a good practice to confirm that the box they're checking is actually true information. But the form actually contains, like I said, an incorrect statement. So the old forms said that as well. And the good news is this has never really been a problem for filing expungement. There's never really been seemed to be any pushback from the courts based on this incorrect statement of the subsequent conviction rule, as long as, of course, the client actually is eligible under the real language of the statute. You will be totally fine to just use the court form as provided, but I just mention it because on the one hand, it's simply interesting to note. On the other hand, it might trip up someone who's double checking their own work. I did see the chat come through asking, will the slides be shared with us after the presentation? Yes, this presentation is one being recorded and can be rewatched. It will be posted on our website, and we'll also just post the slides themselves on our website after the presentation. So a little bit of the procedure for helping a client complete expungement petitions. We are looking at just a screenshot of this expungement web tool that MVLS operates. This is a free Google Chrome browser extension that can be installed. There is a link on our website to install it. If you use the Google Chrome web browser, it's pretty easy to do so. And we have a short training video if you want to learn how to use the tool. What the tool does is, if you are looking at either Maryland Case Search or MDEC Smart Search, which is basically another version of Case Search that's attached to the e-filing system that is publicly browsable. If you're looking at a criminal case on one of those sites, court-operated websites, you can use the tool to basically read the information from the page, and it just fills in the blanks on the expungement petition. And then it also fills in your office address and the client's address as the defendant or petitioner. So this is really just a quick little preview of what it looks like. If you had ever used MD Expungement before, which is the program we used to operate, that actually is defunct due to some technical issues with the way Maryland Case Search works internally through the courts. This is a new program that just kind of operates differently on a coding level and can be used on Maryland Case Search and Smart Search. But there's more information in our training video on that if you want to use it. And this is a pretty short presentation today. That is all the information on the Redeem Act. Again, it is actually pretty simple, but extremely impactful. So just to recap, the Redeem Act is lowering the waiting periods for already eligible convictions. 5, 7, and 10-year categories exist now for misdemeanors and felonies. The Redeem Act does not alter really any of the procedure or prerequisites for subsequent conviction rule, etc. It does not alter eligibility based on the type of charge or unit rule or anything, other than adding that one single misdemeanor of malicious destruction of property. Okay, I see some chats coming in, so I'm just going to take a quick moment to read that. Does MVLS have materials for people interested in taking on an expungement case? Yes, absolutely. So we have tons of training videos on our website on basically anything you would want to know about the expungement procedure. We have kind of basic expungement 101 about expunging other types of cases, non-convictions. We have trainings on the new laws around cannabis expungement. We have all the court forms and different things you need. We have flow charts that kind of walk you through individual cases to say, is this expungible or not? And we have, of course, opportunities for mentoring. If you've never taken an expungement case before, right now is a really, really exciting time to get into expungement. It is certainly a really good way to get your foot in the door with pro bono work. It is compared to really the vast majority of legal issues you could assist someone with, it is a very low time commitment. And once you file your petitions, it's really just waiting it out and waiting for the court to grant it. Very little chance of having to go to court. Extremely impactful on someone's life based on the relatively little time commitment. And I'll also mention just one more thing on the volunteering and taking a case. We have a pro bono portal where you can just see active cases on our website. Those are clients waiting to be matched. You can sort them by case type, and you can look at all the people looking for expungement assistance. And of course, I'm available anytime and more than happy to help any volunteers taking on expungement cases. So a couple more questions. Is it still the case that every conviction, including the most recent, must be eligible for expungement before prior convictions are eligible? Yes, that is the subsequent conviction rule. So the subsequent conviction rule just basically says if you have a new conviction that happened within the waiting period, you have to wait until the most recent conviction becomes eligible. And then you can file all eligible cases at once on different petitions. You fill out a petition for each individual case. But once the most recent one becomes eligible, as long as there's nothing else that's blocking, like an ineligible conviction, you'd be able to just file them all. Another question says, are there possible workarounds for something like second-degree assault? For example, good probation recommendations, good rehabilitation, etc. So it sounds like you're asking basically about a good cause exception for basically getting expunged before the waiting period. So there actually is good cause built into the statute. Funny enough, I don't think the good cause language is explicitly in 10.110, the conviction statute, but it is in the expungement statute generally. And there is case law interpreting the good cause provision to basically only apply to the scenario you're describing. So applying to getting something expunged early before the full waiting period is completed. In our experience, the courts have placed a pretty high bar on this. There is not any explicit guidance on what constitutes good cause, but in our experience, we have seen that courts generally want to see something pretty explicit stating, but for this conviction, this petitioner cannot obtain access to something that is very much needed, such as housing or employment. So they want to see like a letter from a potential employer saying, we want to hire you, but we can't because we have a policy of this criminal background, clean background, or something like that. So if you can demonstrate to a court that that conviction is standing in the way of something substantial like access to employment or housing, then you might have an argument for good cause. And it is certainly possible and certainly a valid case to bring before the court. Certainly something like recommendations from a probation officer or anything demonstrating rehabilitation would go a long way in making that case as well. I'm just reading some of the other chats and comments to go through some of the other questions. Thank you very much, Henry, for your kind comments. Glad to have you here on the presentation. Is there public outreach planned around these statutory changes, and how can we help get the word out? That's really kind of you to want to help us out with that. We are doing lots and lots of outreach. We have, pretty regular tabling events at job resource fairs and different things. We do have a flyer on our website. We also place this flyer into the Baltimore Beat. We have 20,000 copies of the flyer going out as an insert in the Baltimore Beat newspaper. That's a free newspaper that can be found all around the city. And it's been going in, I think, since September, and it should be going in as an insert in their ongoing and upcoming issues. So that's another way that's being done. But we have many, many of these flyers. If you are interested in helping to distribute them, you can definitely reach out to me at this email address on the screen right now, and we can get you some. Or if you wanted to just print them out on your own from our website, you can go on our website and look at our expungement fact sheet, as well as our cannabis law and Redeem Act fact sheet that have similar information, and those can be distributed. But if you did want glossy copies, we'd be happy to send you some for distribution. So I'm happy to hang out for a minute and see if any other questions roll in. But I really appreciate everyone's attendance today, and really glad to see so much interest in the Redeem Act and the new expungement laws. This is really something that advocates have been fighting for a lot for several years, and it's definitely much needed. It's definitely going to help a whole lot of people who have been held back from seeking employment and housing and all other sorts of collateral consequences that have happened due to living with a criminal record. And thank you all very much for your comments here. Really great to work with you all, and we certainly couldn't do this important work without our volunteers. So definitely keep in touch and keep on the lookout for opportunities to take a case, or perhaps any expungement clinics that we might hold. We don't have any officially on the books right now, but there may be one in December and maybe one in the spring as well. And I would say that taking a case and doing this hands-on, if you've never done it before, doing just like one client is it'll just all click into place. Some of this stuff can be kind of conceptual, but once you fill out a few petitions, most people seem to think that it's a pretty easy process. All right, well, that concludes the presentation. Again, thank you all so much. Great to have you here in attendance, and This will be posted on our website, the recording as well as the slides, along with all the other training materials, flowcharts, etc. So I will talk to you all later.